we're now continuing with the second part, which is defining yourself within the law. Are you an employee or not? And let's start with independent contractors. Now, everybody thought freelancers were independent contractors, so now we're going to start touching that. An independent contractor is typically sole proprietor that hires out their skills for a project or for a deliverable fee. So you're not selling them 3 days of tourist guide. You are selling them the delivery of a 3-day tour. There's a big difference. And the big difference comes in what you are selling. An independent contractor sells a deliverable. An employee sells their time. So you might still be paid for 3 days in both cases. But if you're an employee, you are selling 3 days of guiding. If you're an independent contractor, you are selling the successful delivery of a tour over 3 days. Right, so what are the advantages to an operator or to anybody else that makes use of contracted staff? Well, basically, if you contract staff, you are more flexible because you can have a diversity of skills that you don't need all the time. Let's say my business specializes in walking tours of Table Mountain, but now suddenly I have a client who wants to do a walking tour of Table Mountain and finish off with an activity that involves a special skill. Like, come on, Zania, think of an example. A specialist skill that would normally not be part of a tour operator's program. No, you weren't listening. Okay, don't worry. Okay, so apologies. Basically, let's say that what you're offering now is expert knowledge on plants that grow on Table Mountain. So you can contract in a guide like Frank Gowdy, who knows the plants. And that guide can give the clients the expert knowledge on the plants that the normal guide, who is an adventure guide and goes up Table Mountain every day, might not actually have, because that guide is not an expert on plants. So contracting allows you to do that. You can hire in independent contractors. You can scale your resources. A typical example is something like a major sporting event, the Olympics, the World Cup. An operator does not have 300 guides on their books every day, but suddenly they need 300 guides. So you can employ these guides as independent contractors, quickly use them for the event, and after the event, you can let them go again. There is no retrenchment, there's no notice period. So having a flexible workforce is very important where there are high growth phases, which are marked by uncertainty and fluctuating workload. So there's a new route that opens and flights are coming in direct to Cape Town from the USA. The operators might suddenly need more guides, but they don't actually know if they're going to be filling those vehicles. So having flexible workforce is what gives them. Now, the South African Revenue Services, SARS, our favorite organization, have published an interpretation note, which is known as Interpretation Note 17. And this is the one that you use to determine whether a person is an independent contractor for employees' tax purposes. That's the PAYE, pay as you earn, that gets deducted by the operators from your pay. Now, the first time I looked at interpretation notes was in 1999 when I resigned from a full-time job. And actually, no, 96, when I resigned from a full-time job and I became a small business. And I needed to ensure that my business complied and that I could provide services through a CC and that I was considered an independent contractor. So I started looking at these interpretation notes. That was in 96. Now, this latest one sits on top of the Income Tax Act of 1962. And the Income Tax Act of 1962 says that before employees' tax can be levied, in other words, before an employer can take PAYE, pay as you earn, from your salary, there are 3 things that are required. One of them is that there is an employer. Secondly, that there is something called remuneration. And the third thing is that there is an employee. So before they can take tax, there has to be an employee relationship, employer-employee. So to decide this, it is important to know whether you are receiving remuneration as defined in the Act. This is the Income Tax Act, to decide whether you are an employee or not. Now, the word remuneration is actually the important word, because an employer will be liable for employees' tax in some cases, and that's what employers don't want to be. They don't want to be liable for your taxes. So what is the definition of employee? If we go back to that interpretation, note 17, it's broadly defined. When they use the word broadly defined, that means that SARS wants to throw the net as wide as possible and make as many people as possible employees. So basically they say any person deriving remuneration is an employee. And they include in this definition of employee what we call personal service providers or personal service companies. Now, a personal service provider is a small company or a trust where a connected person in relation to such a company or trust renders personal services. Okay, so what is a connected person? A connected person, in my case, could be Zania. It could be my mom. It could be Zania's kids. It could be Zania's grandkids. Any family member, even adopted children, are connected persons. So where a connected person renders personal services. Now, guiding is, in most cases, a personal service. It's not a service that is not rendered personally. So if such a connected person would be regarded as an employee of the client if they rendered the service directly to the client. What that says is, if I have a connected person in my company and I offer services of that person to a client, and if that same employee of mine would have been considered employee of the client had they been working for the client, then that means that the service I'm offering is a personal service. So if the services are mainly rendered also at the premises of the client, and the premises of the client is also broadly defined, so it could be where the service is being rendered. So let's say that I'm doing a job for person A, but I'm being paid by person B for that job. According to SARS, whether I'm doing the services at the premises of A or B is irrelevant. Both of them are the client. So they are making it as broad as possible. And the third one is if more than 80% of the income of the company or trust is derived from a single client. So let's say you do 80% or more of your work for one tour operator, then you're not independent. You actually work for that operator. Right, so there's a proviso, and that proviso is that if the company or trust employs 3 or more third-party employees, in other words, 3 or more employees that are not family members on a full-time basis, it is no longer considered a personal service provider. So you can offer personal services. Your daughter-in-law can be the person offering the personal services. It could be offering the personal services at the premises of the client, and that client could represent a very large part of your income. But if you have 3 or more additional employees in your business that are working full-time for you, you are no longer constituted as a personal service company. So that is the definition of a personal service company. So what is the definition of remuneration? And I said they are throwing the net broadly. Remuneration is any amount of income paid or payable to any person by way of salary, leave, overtime, bonus, gratuity, commission, in cash or otherwise. So basically almost any form of income. And there are some exclusions. Remuneration specifically excludes amounts paid in respect of services rendered in the course of the trade. In other words, if you are paid for independent work, which we have discussed, that is not covered. And also, if you are running an independent trade, so independent contractors would then not be receiving remuneration. So we need to get back to what is the independent contractor. There we go. It is a responsibility. Read this first paragraph. Very important. It is a responsibility of the employer to determine whether the provisions of exclusionary subparagraph 2 of the definition of remuneration are applicable and whether payments are subject to employees' tax. It is also the employer that is in the best position to evaluate the facts. An employer who has incorrectly classified a worker as an independent contractor is liable for employees' tax that should have been deducted, as well as the accompanying interest and penalties. The employer does have the right to recover the tax from the worker. So if you work for a company, and that company, that tour operator, does not deduct tax from your income because they are in the best position to evaluate the facts and the actual situation and decide that you are not an employee, that's fine. But if for some reason the South African Revenue Services decide that you were actually an employee at the time, that operator is then liable to pay to the taxman the money that they should have deducted as taxes with interest and penalties. And they have the right to come knocking at your door and recover the tax money from you. Now you will understand why many tour operators insist on deducting tax. They're not doing it because it's fun. They're doing it because they have to. So it's important for employers that make use of independent contractors to evaluate the relationship with the contractors and to ascertain whether that worker or contractor is an employee for employees' tax. Because if they don't do that, they could have a tax penalty. Okay. Some guidelines that indicate whether an independent business is in fact independent. These are some very basic ones, but if their entrepreneurial enterprise has such a degree of independence that it can survive the termination of the relationship with the client. So you work for tour operator A, and then tour operator A stops using you for whatever reason. Will your company survive without the income of tour operator A? That indicates an independent business relationship. It doesn't prove it, it indicates it. This is all very fuzzy. There are lots of gray areas, and there are lots of different criteria that we will be touching upon. All these different criteria are all used by SARS to look at a matrix, give it weighted values, and decide whether you are an independent contractor or an employee. So when they're evaluating if a person is an independent contractor for employees' tax purposes, there are two tools that are called the statutory tests and the common law test. So the statutory tests are broken up into the first one and a second one. The first one decides that you are not carrying on an independent trade if you are subject to supervision and control at the premises of the client. So it's very difficult with tourism because we don't normally operate at premises of clients. We are on the road. But when a tour operator gives you an itinerary and says you have to be at the restaurant at this time, you have to arrive at the lodge at this time, you must drive this route, you must make a toilet stop at that gas station, because some operators do that. That is putting a lot of supervision and control on the guide. So it makes it very difficult for the guide to claim that they are operating an independent trade. So that would be the first one, which will be, which will say that you are not regarded as an independent trader. Statutory test 2 can override test 1. And that is the one that says if you have 3 or more unconnected, not family employees working on a full-time basis for your business. So if you're not a one-man show, if you're a small business and you have 6 employees and more than 3 of those are not family members, it overrides test 1, and then the supervision and control becomes irrelevant. Then the last part is what is known as the common law test, or the common impression or dominant impression test. And this is the one that I spent a lot of time looking at many years ago. And it is not a conclusive test, it is an interpretation test. So basically, it's not a checklist where you say, There are 20 questions. I've ticked off 5. There are still 15. Therefore, I'm not. No. The way it works is there's an auditor. That auditor tries to understand your business and how your business operates. And it then looks at which ones of those tests are more relevant and which ones of those tests are less relevant, and uses them to get a dominant impression of how your business operates. Does it operate independently, or does it operate as an employee? So this is the SIFE's document, Interpretation Note 17. As you can see, it was issued on 5 March 2019. So a lot of things have changed since I started looking at it. And it's a new interpretation of something very old, and it's for employees' tax on independent contractors. It's very important that all TOs, tour operators, and all tour guides familiarize themselves with the contents of the interpretation note, because it can have far-reaching implications for their business. So let's look at some of the more relevant features, and this will explain also why by default tour operators should actually be deducting tax and paying UIF contributions. So on independent contractors, the first test: a person will not carry on a trade independently if both parties of the test, if both parts of the test are satisfied. So if the second test applies, it overrides the first. That's what we already covered. So it's the supervision and control. And it's also the second part. You're doing it at the premises, part 1. You are being supervised and controlled, part 2. Okay, so subject to employees' tax. It could be that you will be subjected to employees' tax but not classified as an employee, because the independent status as an independent contractor is still covered by the dominant impression test. So they might say, we need to take tax from you, but you are still an independent contractor. So the second test is the 3 employees that are not relatives, not family member, and that is the one that overrides the first one. And here's the common law dominant impression test. The test uses different indicators. No indicator is conclusive. As I said, it's a gray area with a scale of weighted values. It's an analytical tool. And what they are trying to assess through this is whether the individual worker or business is actually independent. So to be an employee of somebody means that you offer your effort, your service, your productive capacity. To be an independent contractor means that you're offering the output of that productive capacity. This is what they are investigating. Are you giving man hours, or are you giving a result? So these are some of the indications, and basically they have what they call near conclusive, persuasive, and indicators. So basically, let's just say the top ones are very high probability, the middle ones are an indication of maybe it affects it, and the bottom ones are, these are just some hints. So the control of manner, the payment, do you get a monthly payment every month? Person who must render the service, can you appoint somebody else that is your employee to do the job, or do you have to do it yourself? So when an operator says, I'm booking guide A has to do the job. Or does the operator say, I'm booking a guide, please provide one? Then you can provide guide B or C. The obligation to work. You can say, I don't do the work today, I will do the work tomorrow. You can't do that with a tour because the dates are fixed. So there is an obligation to work. But because it's the nature of the actual industry, it might be possible that that is less important in the case of a guide. Your client base. You work for more than one tour operator. If you're an employee, you don't work for more than one tour operator. You work for one tour operator. So the broader your client base, the more clients you have, the more competition to your main clients you have. So you work for company A and you work for company B. And company A and B are both in the same market and they compete against each other. That means that you are probably not an employee. And there's also the risk, profit, and loss. Who is risking making a loss on the tour? You or the operator? If you carry some of that risk, the more of that risk you carry, the more of the profit you carry, the more likely it is that you're independent. The persuasive indicators are things like receiving instructions or supervision, having to send back reports. So if you have to send a report every evening, the chances are that you're an employee and not an independent contractor. If you're being trained by the operator in that operator's way of thinking, and you are wearing that operator's uniform, and you are branded, and you have productive time, they are looking at controlling the hours that you work. So basically, what this means is that the more of these things that are weighing in the favor of being an employee, the less likely it is that you're an independent contractor. Then you look at the rest. Tools. Do you provide the vehicle, or does the operator provide the vehicle? Do you operate river cruises? Are you running a kayak tour? Who owns the kayak, an operator or you? Do you have kayaks for all the guests? Where's your office? Do you work out of the operator's office, or do you work out of your own office? How integrated are you with the work premises of the employer? How integrated are you in their business operations? When they show an organogram that says, this is our foreign language division, and our French department is led by Guide C. Well, that means that Guide C is part of that organization. That guide is on the organogram. The duration of the relationship. Have you been doing work for this company for 6 months or a year? If you're working for them for a year on an ongoing basis, the chances are that you're an employee. Can you sue them for termination or breach of contract? Well, then you're an employee. So there are lots of different criteria that people would be looking at. I see there's a question that's come here from Nick that says 24 hours for a tour operator. Do I have a choice of being an employee or not? Okay. Basically, most guides tend to want to avoid being an employee. They like the idea of being an independent contractor because it gives them more flexibility. And usually you get a better pay package if you are not an employee and you are a freelancer. But having worked more than 24 hours a month for an operator, you can probably go to the operator and say, I do more than 24 hours for you. Therefore, I am by definition an employee if we look at the dominant impression test. So the question then is, was there tax that wasn't deducted? Were there contributions that should have been taken? And you can then take it from there, and the operator will then have to either decide to bring you in or not. And they will be liable for back pay if the SARS audit goes against them. So it's a very tricky situation, because what you could be doing is you could be setting up, let's call it a very unhappy experience for an operator, which at the moment might be beneficial to you financially, but in the long term, it would do a lot of damage to your relationship with that operator. So it's probably better not to stir the pot too much now, and rather look at, once business resumes, to follow up on it and say, look, this is how much work I do for you. I've been doing more than 24 hours a month for a period of 3 months already consecutively. Let's have a look at our relationship, and let's start looking at things like taking UIF deductions. I don't think it's possible to reinstate UIF for April, May, and June anymore, because there was a cutoff date from Department of Labor, and that's probably passed already. So it's unlikely that doing a step like that would actually be of any benefit to you right now. But it could be in the future beneficial to have a look at the relationship and say, I want to be considered an employee, so that UIF can be taken off my salary and contributed by the operator. It's 1% from you, 1% from the operator. And it would have been great to have it now. Unfortunately, it's always nice to look back at things and see the opportunities that were missed. So I personally wouldn't push it now, but I would contact the operator and say, for future reference, let's do it that way. I don't know if that answers the question. I hope it does. Okay, so let's now forget about independent contractors and look at employees. If you have a contract and you're regarded as an employee, you are covered by the Labour Relations Act and the Basic Conditions of Employment Act. And there we go. More than 24 hours per month is automatically protected by minimum standards as set out by Basic Conditions of Employment. So in all probability, there would have been a pay-as-you-earn monthly tax that would have been deducted from the salary and also UIF. And I've put contractor in brackets because you are a contractor, but not an independent one. You are an employee in this case. There might even be reference to bonuses in the contract. There might be a restraint of trade clause. Now that's a very interesting one, because a restraint of trade cannot be in a contract with an independent contractor. It's not possible. If an operator says to you, you may not work for the competition, or you may not work for that company, they are basically saying that you're an employee. You can't have restraint of trade. You can't stop a plumber from doing plumbing at other people's houses. Pick n Pay can't say to the plumber, you can't work for Checkers, unless that plumber works for Pick n Pay as an employee. If that plumber is an independent contractor and comes in to do a repair, he does it at Pick n Pay today and at Checkers tomorrow. So it's very important that the contract be set up so that it is transparent, and that any rules that are included, like restraint of trade, are there for a reason and not as part of, let's call it the camouflage, the layer of grass and paint covering the actual reason for the contract. So what laws are applicable to employees? The Labour Relations Act, the Basic Conditions of Employment Act, the Employment Equity Act, and the Income Tax Act. They're applicable to employees. They are not applicable to independent contractors. Right. These are some references that you might want to look at later. I haven't actually put them in as links, but there's a very nice publication which is called labourguide.co.za. And Labour Guide has got lots of rules, explanations, guidelines. It is a real treasure trove. So for any legal problems, look at Labour Guide, it will help. LabourWise is similar, not, well, in my personal opinion, not as comprehensive. Paymaster is all about pay. I've just referred to some of the information. It's not so much about all the labor issues. Then, note, if it's possible to do a screen capture of that HTTPS, www, SARS-CoV, ZA, all docs, and paste that into your browser window and go there, you actually access the Labour Relations Act, which is the one that we've been discussing. And the practice notes are in there, the ones that they look at and consider all the options for the dominant impression test. So it's worth looking at it. Okay, so here is the first question. Does an independent contractor undertake to perform a specific service or task for payment upon completion? So if you're an independent contractor, are you contracting to deliver a specific service or a task, or are you contracting to deliver 40 hours of guiding, 3 days of guiding? The answer is a yes, because if you're an independent contractor, what you're offering is a specific service or a deliverable or a task. And upon completion of that, you are getting paid. You're not getting paid because you had clients for 3 days. You're getting paid because you delivered the 3-day tour. You delivered the product, not the man hours, not the 3 days of guiding. Right. Next question is right click. Yo, I'm not good with the mouse. I'm good with the trackpad. There we go. Does an employee charge per deliverable completed? So, does an employee charge per deliverable completed? So if you're an employee, not an independent contractor, an employee, are you charging per deliverable? And think about it. When I'm saying deliverable, I'm saying that you are providing an invoice to a tour operator at the end of the tour. Are you charging for the tour, or are you charging for the 3 days that you were guiding, or the 5 days that you were guiding? You're an employee, remember. You're not an independent contractor. So you're not saying you provided the 24-day South Africa experience. You provided 24 days of yourself. I'm giving you the answer. Maybe it's confusing. Yeah. Okay. So the answer to that one is no. An employee does not charge per deliverable completed, although it might be a milestone in the process. The employee charges for their time. So they get paid for the hours that they worked or for the effort that they put in, not for the actual. Could you include a restraint of trade clause in an independent contractor contract? So for an independent contractor, can you say to an independent contractor, you're not allowed to work for that company? Restraint of trade. This is actually a very interesting one, because I know there are a lot of guides operating in some industries that think they're freelancers, but they work mostly for one single tour operator that operates in a certain area. And they have basically been told that they are independent, they are freelancers, they are not employees, but they're not allowed to work for any of the competition. Well, that's actually not right. There is no restraint of trade on an independent contractor. So the answer is no. And there should be another question. Can you include a non-disclosure clause? Can you include a non-disclosure clause in an independent contract, independent contractor contract or agreement? You know what a non-disclosure clause is? A non-disclosure clause is where you say, you may not reveal our company processes. You may not reveal the rate that we are paying the hotel. Those are non-disclosures. So can you include that in an independent contractor contract? Okay, so the answer to that is yes, because the independent contractor is operating independently for your business, and they have an obligation to deliver the best possible service. That does not mean that that independent contractor is allowed to use information gained while working for you for the benefit of themselves or other clients. So the answer is you can include a non-disclosure clause in an independent contractor agreement. Okay. I'm being told that I'm